Welcome back to day 3 of the ethics conference. I thought yesterday's discussion and give and take was really good. And one of the things that I'm sure sitting from your position is, okay, what's the answer? What are we supposed to do? How are we supposed to act? Well, this afternoon you get a chance to delve into that. That's part of the reason why you're here this year. It's part of the reason why we have this conference, because in a lot of these issues there certainly is no school solution. And it's for you as the individual military professional to seek out for yourself what is the best way once you fully understand your role and responsibility as a military professional in the ethos of your individual organization. So I hope that during your seminar discussions this afternoon, one of the things that you will get into is just, along with all the other topics, including today's, is getting into some of the things that were obviously left hanging from yesterday's very, very interesting give and take. Beautiful day here in Newport. I was hearing some conversations around the hallway, and I just want to squash one rumor. It's true that Martin Cook saw a shadow this morning, but there will not be 6 more days of the ethics conference. I just want to clear that up. He's happy about that too. Over the last 2 days, we have touched on many subjects that are part of the ethics of the profession of arms. This morning, we want to take a step back from professional ethics of the individual, officer or group of officers, and look at some of the legal and ethical challenges we face in 21st century warfare and post-conflict responsibilities. To that end, our first speaker is Major General Charles Dunlap, United States Air Force, retired. General Dunlap is Associate Director, Duke University School of Law, Center on Law, Ethics, and National Security. Prior to his retirement in June 2010, General Dunlap served as Deputy Judge Advocate General of the United States Air Force. In that position, he assisted in the professional oversight of more than 2,200 judge advocates, 350 civilian attorneys, 1,400 enlisted paralegals, and 500 civilians assigned worldwide. In addition to overseeing an array of military justice, operational, and international and civil law functions, General Dunlap provided legal advice to the air staff and commanders at all levels. He is a graduate of St. Joseph's University and Villanova University School of Law. He is also a graduate of the Armed Forces Staff College and Air War College, and is a distinguished graduate of the National War College. General Dunlap is recognized as one of the most prolific, provocative, and sought-after writers and speakers in the defense and public policy communities today. Totaling more than 120 publications, General Dunlap's writings address a wide range of issues, including the law, air power, counterinsurgency, cyber power, civil military relations, and leadership. He has spoken at numerous conferences and institutions of higher learning, and it is a real privilege to welcome him back via VTC to the Naval War College. His subject this morning is Lawfare, Legal and Ethical Constraints in Modern Warfare. Please welcome General Dunlap. General.
I started talking about looking for a way of translating to non-lawyer audiences the complexity of law in modern warfare. And to be perfectly honest with you, sometimes the language of the law doesn't translate very well. And language can be very important. One of the wonderful things about being in the military is you do have the chance to travel. And one time I had a chance to go down to South Africa and visit with their Air Force down there, and specifically their Air Force JAGs. And they took me out to dinner. the folks at Naval War College know that I try to be a good vet. In other words, I was trying to sample all South African wines that they had at this dinner, and I picked up this one bottle and I took a hard look at it, and the label was entirely Afrikaans. And Afrikaans is one of the 22 official languages in South Africa. And I poured a little glass, and to be perfectly honest with you, it was really bad. And all the South Africans turned and they were kind of looking at me, and I was drinking this stuff, and it goes on for several minutes, and finally one of the wives of the South African officers, she leans over to me and she says, "Sir, you do know that you're drinking the salad dressing." So sometimes, understand. So, lawfare, why lawfare? Well, actually, the legal aspects of armed conflict are becoming a strategic concern. I have a lot of thoughts about that. We can talk about it during the Q&A. I think it has to do with globalization, because in globalization, you need to have law and international forums to have international trade. And that has driven the focus and a consciousness of international law and law generally that maybe hadn't been there even as few as a generation ago. And there are powerful economic incentives to make sure that there are these rules which control trade. And like everything else, things in the economic sphere tend to drift over in and impact warfare in some way. Senior leaders recognize this trend. General Jones, when he was the NATO commander, had this famous observation that was in that important military journal, Parade Magazine, but I think he captured it well, that one concept of what warfare is versus what it is today. And I don't particularly say that it's a great thing that modern war has gotten so legalistic, but the fact of the matter is that's the way it is. And so lawfare was designed to try to help to explain to warfighters and others what it means to have a legalistic way of warfare. Lawfare today, terminology, when I first started using it, I had this idea that somehow I had invented the term, but I really hadn't. Some guy used it in 1975 in different contexts. But when I Googled it, you would get 5 or 6 hits. And as you can see, it's gotten into the literature in many different ways. And most meaning, which had something to do with landlord-tenant relations in Australia. But the modern the way most people think of it is in the following context, where you think of law as a strategy of using or misusing law as a substitute for traditional military means to achieve an operational objective. So conceptually, I think it's helpful to think of lawfare and the law as a weapon. In other words, many people say, well, with lawfare, you're saying law is bad. I'm not saying that. All I'm saying is that it can be used in good or bad ways. It's ideologically neutral, in other words, and it can replace military means. And I want to emphasize that not all lawfare is bad. In fact, we used it. You might remember in the beginning of Operation Enduring Freedom, there were companies out there, commercial satellite imagery companies, who were selling overhead shots of our certain sensitive areas in Southwest Asia. And there are a number of things that we might have been able to do from a military perspective to stop that kind of information from getting into the bad guys' hands. But instead, a legal weapon, so to speak, was deployed where we bought up all that imagery for about $20 million and then used that methodology to prevent the information from getting to the bad guys. And I think we'll continue to see this in the future. one of the main ways of addressing terrorism really is to dismantle the financial support for terrorism. And that will principally be through legal means. And when we think about one of the terrorism's other great elements to support the internet, I think that in the future and contemporaneously, we're seeing most of the effort going to legal means to try to address an adversary's use of the internet. And as a counterinsurgency strategy, it's a key element of our counterinsurgency strategy. Those of you who have served in Iraq probably know about the rule of law complex in Baghdad. It was an enclave that was built where because one of the main problems was the judges and the prosecutors were coming under so much pressure that they built an enclave with the prison, the courts, the prosecutors. They live in the rule of law green zone, so to speak, and were able to help reestablish the rule of law, because that is one of the key elements of a successful counterinsurgency. So while the term is not used in the doctrine, or you won't find it in the strategy documents or the operational plans, it is in effect a lawfare strategy. And more recently, the rule of law complex, they built the same thing in Afghanistan. And so we're seeing this methodology, the reestablishment of the rule of law. Lindsey Graham, who is an Air Force Reserve Colonel, JAG, made this comment, which I think captures the role of law in the counterinsurgency context. And so rebuilding it is one of the ways that we use law in the 21st century. But most of our adversaries use an abusive form of lawfare that often manipulates the respect for inherent law. And why? Well, most of our adversaries can counter symmetrically, and they're especially concerned about air power. They don't have an air force. They don't have air defense weapons, at least no comprehensive air defense weapons. And so they're looking for a way of countering that. And I think it's fair then to think of lawfare as a form of asymmetrical warfare. And it's extremely difficult for them to counter. This is just one example of things that we see coming out of the AOR about their view of air power. And they see lawfare as a low-cost way of offsetting. And one of the ways is to ignore international law to gain an operational advantage. Here's an example from the first Gulf War. I'm sorry this is a little bit hard to see, but if you look at where those arrows are pointing, they're pointing to Iraqi fighters. And that building that they're next to is called the Ziggurat of Ur. The Ziggurat of Ur is one of the most important archaeological sites in the world. And they drag those planes next to that object in order to discourage an attack on those planes out of fear of destroying this archaeological treasure. In point of fact, those planes were not attacked, but under the law of war, you could attack them. Now, the main reason they weren't attacked was, as long as they're parked next to that, next to the Ziggurat, not a threat to us. And as the aviators in the audience would know, you probably don't want to fly a plane that's been sitting in the sand like that, for a couple of days without breaking down the engine and so forth. So the view was that we would have an opportunity to get after those planes if we needed to. But nevertheless, this is an illustration of a mindset of some adversaries who don't have the military means of fronting us in a traditional way. They're trying to use this asymmetrical way of confronting us by calling upon our adherence, trying to turn our adherence to the rule of law into that they can exploit. And another way is to use the law as a decapitation strategy. I'm sure there's people in the audience who have been to Colombia, one of the most interesting countries I had the opportunity to go to when I was on active duty. But what happened down there is that The United States has provided a lot of money to Colombia under Plan Colombia, but it was contingent upon certain human rights training and passing certain human rights laws. Well, the Colombians did that, and as you can see from this quote, the insurgents figured out a way to turn that into a vulnerability. And under law at that time, it took literally years to resolve these issues. And in the meantime, the commander had been relieved from duty. So it was a way of attacking command and control without actually physically doing it in the traditional military means. And other forms of lawfare really are kind of a psychological way of undermining our symmetrical advantages. And some of this resonates in the classic theories of warfare. Those of you who have had a chance to study Clausewitz know that he talks about its remarkable trinity. He doesn't use the words the government, the people, the military, but when you read the phrase, the traditional analysis of it puts it in that way. In the West, we principally try to deconstruct the adversary's remarkable trinity by denying or destroying the adversary's military capability to wage war. But our adversaries don't really try to destroy our military capability. They know they're not going to be successful. So they look at deconstructing differently. They're trying to separate the people from the government and the military by undermining our will. And there's lots of ways in which they seek to do this. One of which, though, is using and particularly actual or perceived legal or ethical violations. And Bill Eckhart, who's a law professor, had been one of the prosecutors in the My Lai massacre, wrote an article where I think he captured what we're really talking about today in terms of what the adversary is trying to do to take advantage of our adherence to the rule of law. And in a real way, you can say law has become a center of gravity today. So perceptions of low act violations, and by low act, I mean the law of armed conflict, and it can have real operational effects. And an example from the Gulf War I don't know if many of you remember the Alfredo's bunker. This was a bunker where if you looked at the imagery, you would, and you know how the imagery analysts look at radio antennas and so forth, it was determined that there was I think that French Carrier air command and control system was present in this bunker. But in fact, a lot of the families of high Iraqi officials were using it as a bomb shelter. They would have been much better off just staying in their homes. Well, this facility was attacked. We didn't know that it was being occupied by the families. Doesn't mean necessarily we wouldn't have attacked it, or we could not have legally attacked it, but in fact, we know it. And we hit exactly what we intended to hit. But the spectacle of the bodies being dragged out from that facility, especially the bodies of the civilians, had a political effect with restriction on bombing downtown Baghdad. I think some of our adversaries have gone to school on this and concluded that creating these kinds of incidents is a better way to defend against air attack than the traditional way of trying to have fighters and so forth. And we'll see this develop. I believe it's a specific strategy that our adversaries are employing. And I think that's important to view it as an explicit strategy and expect adversaries to be planning on orchestrating these kinds of events for the explicit purpose of countering our symmetrical capabilities. Again, not happenstance, but part of the strategy. And of course, the actual law of war and conflict violations can have strategic effects. And they really are indistinguishable from a traditional military defeat. And ask yourself, what is the most serious setback that the military has had since 9/11? I would suggest to you the most serious defeat, in essence, that we suffered was Abu Ghraib. General Petraeus recently, not too long ago, said that Abu Ghraib is non-biodegradable. In other words, it is still in the consciousness of the Iraqis and other people in the Middle East. It is still a setback for us. And what's so ironic about it is it did not involve the loss of troops or did not involve combat in any traditional way. But you see General Sanchez use traditional military terms to describe its effect. And it did have an effect. And I would submit that Americans have died because of what happened at Abu Ghraib. It energized the enemy. It increased recruiting. It made achieving the operational objectives that much more difficult. And so it really is an effects-based kind of warfare, if you would have it. So we're seeing, what are some of the challenges for leaders and decision makers? Well, LOAC does have a legal dimension, and there can be. So this shot from the Nuremberg trial, of course, the General Yamashita. What's interesting about the Yamashita, he never committed a war crime personally, but what he was hung for was failing to take adequate action to suppress war crimes committed by his troops. And you see the box down in yellow, that's from Protocol 1 of the Geneva Conventions. We, the United States, are not parties to Protocol 1, but I would suggest to you that this may be part of what we call customary international law. And it establishes the obligations of leaders to take all feasible measures to prevent law of armed conflict violations. And I can tell you, I never thought in my lifetime that I would see a head of state brought before an international tribunal like Milosevic was. That was not a real advertisement for international justice, because Milosevic was on trial for 4 years and then he died. But nevertheless, we're seeing more and more of these international tribunals. And of course, now we have the International Criminal Court. The U.S. isn't a party to it, but it purports to extend jurisdiction over countries and individuals who are citizens of countries who aren't parties to the treaty. Within our own law, we see repeated prosecutions for things that are in essence war crimes. And the U.S. military has been pretty aggressive about prosecuting people for things that are in essence war crimes. So there's clearly legal dimension. And even in Israel, you know, more recently there have been, and the Israelis did a pretty good job of trying to adhere to the law in recent Gaza war. And there's been a number of investigations, but they've even taken disciplinary action against their own people for things that are perceived to be violations of the rules of engagement or violations of international law. And there's a moral dimension as well. What you've seen on the screen now is not from the most recent Gaza war. This is, I think, from several years ago. But to make a long story short, several Israeli pilots signed a letter which said that they weren't going to fly missions anymore over the Gaza because of legal and moral qualms about doing so. I've been told that, I've asked whatever happened to these guys, and I understand, and perhaps with somebody in the audience who would know better than I, that they were given letters of reprimand, but that was pretty much that they were assigned to other duties. But I think it illustrates an important challenge for military leaders. There was an article in Slate Online a couple years ago. As some of you know, In the prior administration particularly, there was much dispute between the military lawyers and the civilian political appointee lawyers over things such as interrogation techniques, military commissions. And the military lawyers were, in essence, more conservative and wanted to adhere to the traditional notions of the Geneva Conventions and so forth. And Professor Strager at the University of Virginia wrote a really fascinating article, interesting because he's not a JAG or hadn't been a JAG, but he really, I think, perceived that why military lawyers looked at things differently. Because people in the military need to know that what they're doing is legal and moral. This is one of the factors in the kinds of troops that we have. It's a very attractive factor, but it's something that you ought to take into account as you do your preparation, the legal, what I call later on, the legal preparation of the battle space, because people need to know that what they're doing is legal and moral. That's why it's good to be able to tell them, look, the lawyers have looked at this, and they need to have that in their intellectual database that somebody has looked at this and this is the right thing to do. And so what I would suggest to you that it's very pragmatic and strategic imperatives with respect to the law of armed conflict. It is not just, we obey the law because it's the right thing to do and it's the ethical thing to do. There's really very pragmatic basis for it, because as we can see, the quasi-government likes to beat us over the head if they believe that there's been excessive civilian casualties. And there was a pretty interesting article in Air Force Magazine a couple of years ago, which I think captures what the challenge is, because it's the perception and, of course, the fact of poor conduct that makes adherence to the rule of law a strategic imperative, because it really can unravel our ability, particularly to wage coalition warfare, if the perception is out there that we're doing things the wrong way. The reality is that every bomb that you drop or every, that you fire has the potential to have a strategic effect, whether intended or not. Okay, we've talked a lot about, what the challenges are and how the adversary is using the law. What can we do to counter it? How do we, in a nuts and bolts way, how do we go about that? And I want to remind you, not all lawfare is bad. Conceptually, it can be used by us as well as, our adversaries tend to use abusive lawfare. But to counter abusive lawfare, I would suggest that we do what I mentioned before as the legal preparation of the battle space. And this is aimed at diminishing the enemy's opportunity to use the law in an adverse way against us. And so how do we do that? Well, for one thing, we have to prepare our internal audiences with the right information. And part of that is training. I can tell you, when I first came in the Air Force, 35 years ago, we did have law of armed conflict training, but it was very, very basic and superficial. And there wasn't the particularized training, especially for senior officers, that we have today. If any of you go to the JFAC course down at Maxwell, find that you have very highly detailed on conflict and rules of engagement instruction. And that is designed for the senior warfighter because it does take into account some of the tricky questions that, as a practical matter, you are faced with. And this is just some of the controversial issues. What we try to do now is to give the commander some practical advice. And part of that is the importance of preserving your decision-making process. Attacks on electrical grids. We try to bring out what the studies have shown and so forth. So encouraging commanders to make data-driven decisions. and data-driven decisions that also take into account the particular cultural norms of a particular adversary. And as I mentioned before, I think it's extremely important that when commanders are attacking a sensitive target, and especially dual-use target, I would make some kind of memorandum of what my thinking was, because sooner or later you may be asked for that rationale. It's not a legal requirement, but I think it's a wise way of conducting business. One of the most complicated things in coalition warfare is most of our coalition partners are members or parties to international agreements that we aren't. We talked about one already, the International Criminal Court. We talked about another, Protocol 1 to the Geneva Conventions. Now, we accept a lot of what are in these other international agreements, but need to sort out with a lot of particularity with your JAG exactly what your coalition partners can or cannot do with respect to the international agreements that they are parties to. Human shields, we can talk about this during Q&A if you want. Tax on radio and television facilities, this has been very controversial out of the Kosovo. You might remember that the Serbs made some of the people stay in a radio and television station knowing it was going to be attacked because they were hoping to have some casualties. Cluster munitions, very controversial. Ironically, when I first came in the military, cluster munitions used to be the right answer for a lot of targets. The classic one being, the AAA is on top of the dam. Do you drop a 2,000-pound bomb on it, or do you use cluster munitions? Well, now, because of the Ottawa Convention, many of our coalition partners won't use cluster munitions, certain kinds of cluster munitions, and other of our coalition partners, because of domestic law restrictions, use them. But nevertheless, that's another complexity. Leadership targeting, there's been a lot of talk about this in recent times, especially leadership targeting outside the area of most intense operations, let me put it that way. And then technology-generated issues. This has really been quite interesting because technology really has facilitated adherence to law principles. Here's a shot from the old CAOC, meaning not the brand new ones in Southwest Asia, the sense of what we're talking about. And the use of the technology has really been effective. There was an article in the New York Times, not exactly the most militarily oriented publication in this country. It was fairly complimentary on the deliberate targeting process. But the reality is today, most of the civilian casualties are airstrikes anyway, are occasioned by unplanned targeting. In other words, troops in contact, that kind of thing, where you don't have the opportunity to do the vetting of the target in the way that you might do with the deliberate targeting process. And I would suggest to you that the more troops that we have on the ground, the more civilian casualties you're going to have, because you're going to have more troops in contact calls. I think it's important that for all that technology has done for us, senior leaders need to know what the limits are. We have compressed the kill chain a lot. Now, just as a quick review for those who may not be as familiar, the kill chain is the period of time between the sensor sensing the target, which may be the Mark I eyeball. In other words, from when somebody sees a target to steal on the target. And a lot of effort, a lot of technology has gone into compressing the kill chain. The result is that junior personnel under a lot of stress have the ability to call in a lot of air power capability. And I think one of the things we have to think about is the fact that technology is now so compressed that time frame That to what degree can you put human judgment against those decisions? And this is coming at a time when the enemy is emphasizing or trying to orchestrate more incidents of civilian casualties because they know the positive gains that they can get out of it. And in Afghanistan, we see the kinds of things that they're trying to do. And consider the predator and the controversy. In the a couple of years ago, Seymour Hawkins was, allegedly coming out of Tommy Franks' mouth, which there's a few words that aren't in that quote that I think if they did come out of Tommy Franks' mouth would have been present, at least as asterisks. But nevertheless, this was viewed. Now, the law is, again, this is out of Protocol 1, that you're supposed to do everything feasible to determine, whether or not these are civilians or whether they're legitimate military objectives. And so when you take a look, that's what people are looking at. That's the information that the predator is going to provide you in your determination whether you're going to kill another human being. It can be the Taliban, it can be civilians, it can be CNN. A lot of commanders at this point would have all the information they would need, of possibly being CNN, to launch the strike. NGOs, remember a lot of NGOs are local national hires. Allies, remember during the early part of OEF, our allies, it was very difficult to distinguish who are our allies and who are our adversaries, or even special forces. Special forces sees themselves as authorized to wear what they call non-standard uniforms. And while there is a cell in the CAOC that's supposed to deconflict the special forces, that's always a concern. There's no right answer here. It's just a reminder of the difficulty of making these decisions. That's why when you talk about capabilities like the Predator, you really do need to consider the totality of the circumstances. Unfortunately, Predator feed can go to a lot of different places. And people without the responsibility for actually making the decision may think they see something on that TV screen and every tall person in Afghanistan who's driving a Toyota Land Cruiser or is in a Toyota is not necessarily Osama bin Laden. And you don't kill other human beings just on the chance they might be the enemy. And so it's funny because as lawyers, there's whole books written on the fallacy of eyewitness identification because there's so many psychological factors that can affect what people think they see. And so visual identification doesn't always equal positive identification. And along this line, you might remember the shoot down of the helicopters in northern Iraq by the blue on blue shoot down from several years ago after the first Gulf War as an example of, you might think, well, how did they mistake U.S. helicopters for Hind helicopters? But part of the answer to that is when you expect to see something, your mind makes you think that you see it. So in other words, these decisions are much more complex. And what commanders in the real world find is other people are watching this same video and not understanding why you're not taking action, but taking action requires a holistic analysis. In any event, addressing the internal audiences is the only part of the equation. You've got to address the external audiences. And that's why it does pay to educate, especially people in the media, exactly what the adversary is doing. And exposing what the enemy is doing can have a positive effect. And a good article by John McCain from a couple of years ago talking about when he was a prisoner of war in North Vietnam. And once it became known exactly what was happening to the prisoners, it did have a positive effect. I like to bring this out because everybody thinks it doesn't have any effect on the adversary, but it can, it does. We're even seeing now among the Taliban is that they're getting some instructions to try to limit the number of civilian casualties. That may just be another form of propaganda, but at least they feel they have to at least put that in their propaganda. And I think it helps a lot to explain a lot of the affirmative efforts. You know, for years, we never let anybody into the CAOC, the reporter, which I think was a huge mistake, because if we show people all the efforts that we go to limit civilian casualties, that can only be a good thing. Different briefings put on the web that CENTCOM put on the web. A lot of people, myself and others, gave interviews to the press. I think it did have a positive effect. And we have to especially counter what the enemy is doing. Now, we can make some mistakes. And let me give you an example of what NATO did. In June of 2007, they put out a press report that basically said this: okay, NATO would not fire on positions of new civilian. Well, a year later, they made it even worse. I think that statement, A, it's insensitive to Americans, but think about what is the message that's being sent to the enemy. Begin with, this isn't the law. The law says that the law accepts and knows that you're going to have civilian casualties. It's just that the military advantage needs to outweigh the civilian losses. In other words, civilian losses should be excessive in relation to military advantage. But what NATO did encourages the enemy to do exactly what we want the enemy to do from a legal and moral and operational perspective. And, you know, when you tell the enemy that if there's any civilians around, they're not going to be attacked by the one weapon that they really fear the most, what are they going to do? They're going to surround themselves with civilians. And that's exactly, of course, what we've seen. And this is just one example of many, many examples of the enemy surrounding himself with civilians as a way of protecting himself from air attack in particular. And you remember General McChrystal. Among the many interesting things that General McChrystal did during his tenure was he virtual ban on airstrikes, or at least severely limited them. And so what did we see a year later in terms of, did it protect civilian casualties? No, it didn't. It did reduce the number of civilian casualties from air attack, but overall, the number of civilians who were killed went up dramatically. And it's not hard to figure out the rationale. Each time you forego the opportunity to kill the enemy, especially an enemy who is responsible for 76% of all the civilian casualties, each time you forego that opportunity, that enemy lives to kill more civilians in the future. And there's, ironically, and this has a lot to do with the psychology of Afghans, there isn't much evidence that the Taliban killing, being responsible for 76% of the casualties has much adverse effect on their efforts. And quote from Ben Arnold. Now, he did contact me and say that, well, he does think it has some effect and so forth, but this is what he wrote at Christian Science Monitor. But in addition to that, in addition to having more civilians killed, we've had more troops killed in 2010. I'm not going to say there's a direct relationship, but I think it's one of the factors that has caused the increase in casualties. And when you look at where the casualties were caused by, there was a study done, a DoD-sponsored study, that showed that airstrikes were responsible for 6% of the deaths of women and children, for which ISAF was responsible, which is kind of interesting considering that 16%, almost 3 times as many, were as a result of high-staff traffic accidents. So, to improve upon the law of armed conflict, it might have unintended consequences. Today, since General Petraeus has taken over, interestingly enough, he's kept in place many of the restrictions, but he's figured out a way to vastly increase the number of airstrikes. And since he's been in charge in Afghanistan, the number of airstrikes has really dramatically increased. And interestingly enough, the alleged CIA use of drones in Pakistan has resulted in many more strikes and many fewer civilian casualties. And there's some complex reasons for that, having to do with technology as well as better information and different changes that the Taliban had. Nevertheless, I think it's important that we always look for strategies, technologies, and processes where we can help defeat the adversary's use of lawfare. And the ultra small precision guided bombs are one technology, and which may make, as Velasco noted, that it may be the most discriminating weapon that exists. But still, I think that while technology is a big part of the solution, we have to remember that there are people out there right this minute working on technologies to disrupt PGMs and different methodologies for doing that. And so that the quality of intelligence is always going to be the key to countering the abusive forms of law. Sarah Sewell wrote an article years ago in the Washington Post, and I think she's exactly right. You know, I think the capability, precision of the weapons, the size of the weapons is getting to the point where, you know, we have the right weapons. It's just a question whether we have the best intelligence. I tend to think that I'm a fan of SIGINT because I think what they say among themselves is always more important than what some people tells us they said among ourselves. Because you can see things can go terribly, terribly wrong when we depend too much on it, as we saw in this case of the investigation from that very serious civilian casualty incident that was on your screen. Lack of releasable intelligence. You know, I think this is something commanders need to think about more in the future. You know, you may not be dragged into court, but the court of world opinion is going to be judging you. So I would think, even though the law doesn't require it, I would be prepared to release as much information as you can when you attack a sensitive target. Let me give you a real world example. Al-Shifra chemical plant, Sudan, this was attacked in the late 90s. There was the perception that it was involved in making of chemical weapons of mass destruction. But there was such an uproar afterwards because it actually did make pharmaceuticals, and it was one of the main sources of pharmaceuticals in North Africa. After that attack, people weren't revealing what the rationale was. Well, eventually there was a lawsuit, and it came out that there was some chemicals in the dirt around the plant that were EMTA, which was a precursor chemical for other chemical weapons, but supposedly, and I'm not a chemist, but supposedly it could be used for other things. The lawsuit, incidentally, was just finalized in June of 2010. It was dismissed not because it wasn't factually valid, it's dismissed on the political question doctrine, which means that the courts will not get into second-guessing the designation of targets by the executive branch. But I think the point is is that I think leaders ought to consider the releasability of supporting intelligence before striking a sensitive target. And adversaries are increasingly aggressive. I mean, they are going to really take the opportunity to really publicize and take advantage of these situations. And it is ironic to me that here, the country that invented Madison Avenue and advertising and getting people to believe things, we're coming up short against an adversary that is otherwise unsophisticated in so many other ways. And so we do need to keep in mind, though, that not every time we get criticized for doing something is necessarily the enemy propaganda. You know, in a free country especially, people have the right to question what their military is doing. And when we do something wrong, then we got to fix it. And we have to hold people accountable in the right way. And I think it's essential to rapidly respond to the allegations and incidents. You know, it's startling to me that in a chaos, you may have people or on the battlefield who are authorized to make life and death decisions, to use a weapon to kill someone, and that same person won't be authorized to talk to a reporter about what happened. You know, it has to be approved by the Pentagon or whatever. This is not the way we need to be waging the war in the 21st century. We need to be able to rapidly respond to instances. And I know a lot of you don't like Wesley Clark or whatever, but I'll tell you, one of the best books, if I was a young officer, meaning you guys and ladies, I would read this particular book of Wesley Clark, not all his other ones, but this one. Really, it's about Kosovo. I think it's more of a template for the future, especially political and bureaucratic peace. But one of the things he says in there about civilian casualties, he said, you know, it's really hard to stay ahead of it because the enemy always knows more than you do because it typically incurs enemy-held territory. So you really have to focus on it. Another part of real world problem we have, and those of you who have been in chaos know this, we have lots of computer systems, but none of those systems are really designed to archive information for the purposes of an investigation. And so when something does happen, it's hard to figure out, you know, who shot John, literally. You know, these days when you're dropping so few weapons, you can capture the MISREPs, the mission reports, and capture the MERCHAT and all that kind of, and look through it to try to figure it out. But imagine, if you will, like the beginning of OIF, when you're doing 2,000 sorties a day, you literally don't know where every bomb's landing. But there is a perception out there that we do. So one of the things I think we need to do is design systems with the expectation that we're going to be asked, and we have to have a rapid way of declassifying information, gun video, and so forth, so that we can counter what we know the adversaries are going to do. A good example of doing it the right way was from early in OIF. There was another one of these, I think this was a wedding party, another one of the wedding party incidents. There was a lot of publicity. There was an investigation, and unlike what was typically done, CENTCOM put on the public website a summary of the investigation, and it was pretty extensive, things that you would not otherwise expect to see. I think that transparency is the wave of the future. In the post-WikiLeaks era, we may have transparency whether we want it or not. But in any event, I think transparency is a great counter-abuse of lawfare technique. And of course, you need to have legal advice. And is this kind of an ad for JAGs? Well, I guess sort of. But what I'm telling you is that you need to have JAG who not only is a good lawyer, but who knows the systems, knows the weapons, knows the tactics, knows the platforms, because what the JAG's job is to do is to advise, commanders decide. but you need someone who really knows your business. And I would suggest most of you out there are going to be able to tell pretty quickly whether you have someone who's creatively trying to figure out ways to do what you need to do in a legal way, and someone who is just falling back on the law without understanding your business and your intent. So, can the effort go too far? Yeah, I was shocked when I saw this in the Wall Street Journal last year. And I don't know how, I don't know if you can read this, but here is a company grade commander on some little hub somewhere who happens to have a JAG there, who they're seeing guys planning booby trap, and he runs to ask his JAG whether or not he can attack it. Well, you know, yes, there are times when you're in the midst of combat where maybe it's appropriate to ask the JAG, but I would suggest to you that the better way is to get good training and to internalize what the rules are so that you can make instantaneous decisions under extreme stress. Because while this may work in certain instances, we can't put a lawyer in every cockpit and over the shoulder of every soldier, nor do we want to do it that way. That is not the effective way of ensuring legal and moral adherence to the rules. Okay, a couple of concluding observations, and then we're going to go to the Q&A. We've been talking about lawfare in a certain context, and mostly against terrorists and non-state actors. But if you look at the Chinese literature, I think the three warfares that's Chinese doctrine now, the third one has to do with legal warfare. And you'll see it more and more that we're looking to use the law as a weapon of war. You might have, if you Google unrestricted warfare, I know a lot of you have seen this. They call it a book, but it's really kind of a monograph that came out, more than a decade ago, where it has kind of interesting observation. I would suggest to you that no Chinese colonels publish any monograph or speak to the press unless it is vetted and reflects the view of the People's Liberation Army. This is a very interesting statement that came out of this Chinese colonel, and it is what we may be looking at in the future. But I'd like to emphasize to people, it doesn't change what we need to do, because the fact of the matter is, in a democracy, you're always going to be restrained by political goals. And those political goals are often going to be driven by public opinion. And the public expects that we are going to wage war in the right way. And it's for our allies too. This is some interesting things coming out of the Gaza war. The Israelis pretty much knew that Hamas and the adversary were going to wage lawfare against them, and they've seen this. There have been all kinds of lawsuits and so forth. And in essence, it's become a continuation of the war by legal means, and this may be the future of lawfare. But the reality is, this is a great quote, I think, from Laws of War written by some Yale law professor. And I think this is the key thing. If people believe, you can be adhering to the law. If people believe that you're not, in a democracy, it is going to erode this kind of public support that you need. So we have to accept that there's going to be a lot of frustrations. British officer, I like this because he saw the link between the underlying concepts of lawfare and Clausewitzian analysis about war being, the political dimension of war. And that has a lot to do with what we've been talking about this morning. So we should ask ourselves, we at a disadvantage because we're ethical and law-abiding society? Well, actually, if you look at a couple of books, and Victor Davis Hanson's books and a guy named Caleb Carr took different perspectives. Victor Davis Hanson, he basically says that he goes through history and he says that on balance, that societies that respect individual freedoms, that have democratic values, that allow speaking and so forth, tend to be better writers than totalitarian regimes. Because, I think instinctively that, well, a totalitarian regime who does anything they want, is going to be a better warfighter. But history doesn't prove that, because what it does, it suppresses the entrepreneurial, the free thinking, the creativity, and so forth that makes for good fighting. And if you do that in the context of a law-abiding society, which permits the free expression, you're going to have a better warfighting. And Caleb Carr talks about societies that waged war against civilians and atrocities. And he goes back through the history of warfare and finds that, no, that actually doesn't succeed. And in fact, a lot of societies who were waging war like that not only were defeated, but ceased to exist in the form that they previously were. So I think that just from a pragmatic, practical point of view, that complying with law actually has a pragmatic payoff in that it generally produces victory on battlefields. It is a war-winning formula. And with that, I'd like to move to the questions and the comments from you. I'll try to. Any questions?
Charlie, this is Martin. I'll have to repeat the questions to you.
Okay.
Because you won't be able to hear them directly in most cases. So we're ready.
So we'll like to call for questions now, and because Martin has to repeat them, please keep them succinct, please. Question in the back, please.
Hey, sir, Navy Lieutenant Doug Robb, thanks for the excellent presentation. As far as what I got from the presentation, there are two reasons to apply criminal law. The first is to hold criminals accountable, but more importantly, it's to act as a deterrent. But if you look to a Navy-centric example in the Horn of Africa, where we've tried to apply law to Somali pirates, aside from the moral warm and fuzzy that we get from trying pirates in limited cases in Norfolk, the Netherlands, and Kenya, it's had no deterrent. So my question is, why bother?
Did you hear that all right, Charlie?
Yeah, I did actually. Well, I'm not sure that it has no deterrent because you take a certain number of people engaged in that behavior and you take them off of the committee to speak. But a lot of times our adherence to the law is more about us than about them, because if we say hung them from the yardarm as soon as we caught them, then that would create a certain reaction among our publics. I think part of the problem, particularly with Somalia, and I did serve in the Somalia operation, is that the rule of law has collapsed within Somalia. So part of the answer is trying to reestablish the rule of law inside Somalia. And what needs to be done with piracy in terms of not just the Somalis, but with many other countries, we can't come in and lecture them about our Western notions of law. One of the things the ICRC did that was good a couple of years ago is they put a book out about the law of war, and they didn't mention the Geneva Conventions. It was aimed at an Islamic audience. And what they did is they went through the Quran, and they found kind of the same principles, and they put it into a context of the Quran says this, the Quran says that. That's the kind of approach that I think that we need to take with some of these challenges, and put it in a culturally, something that resonates in a particular culture. But having said all that, part of the answer is killing and capturing. Yes, part of the answer would be rebuilding the rule of law, using the law as a deterrent. But at the end of the day, there are a certain number of people, the irreconcilables, who have to be killed or captured before their behavior is going to be stopped. So that's why I do think it's of value to have the patrols and keep tamping down the problem until it comes under control. I also think that there's going to be technological opportunities to put systems on, they're looking at a bunch of different systems to put on commercial shipping vessels that will deter the methodologies that the Somalis are using. But I will not say that the law is a total answer. It's part of an answer. It's part of a holistic approach to a very difficult problem.
Question in the back.
Good morning, sir. Lieutenant Commander Barrett Smith. Had a question regarding slide 60, your wedding party example. Where do you draw the line between a legal responsibility for target discrimination that from 15,000 feet may be near impossible when looking through a targeting pod versus carrying out a self-defense strike that may be permissible under ROE? It seems like the fallout for the quote-unquote mistake should be relegated to an aggressive STRATCOM IO piece that should follow the strike because really it's the war of ideas and words versus the legal venue that is more than likely going to occur as an investigation into the strike itself. How do you reconcile that dilemma?
Well, a couple things. Number one, we should do an investigation, not just to ascribe legal responsibility or accountability, but to figure out what went wrong, what is the enemy doing that is making these incidents happen. Did the weapons work correctly? We did a lot of investigations where we found that certain things about weapons, when they sit in the hot sun for years, that sometimes they don't exactly work the way we thought they would. So we need, from a very pragmatic perspective, finding out what went wrong. And I think that there is a certain measure of accountability, but we need to make sure that the warfighter knows that they are going to be backed if they act reasonably under the circumstances. This is one reason why I think it's very important that situation where we feel that the warfighter was wrong and was negligent in a criminal way or was, purposely did something, that we ought to use the military justice system. Because people outside that system don't necessarily understand or have internalized the difficulties of the warfighting situation. And it's interesting to me that one of the Marines who was charged, I think it was in the Haditha case or one of the cases, had already been discharged, so he was tried in civilian court, and he was acquitted. And they interviewed the jurors, and the jurors basically said, well, we can't really judge what it was like to be in combat with people shooting at you and trying to determine the targets. And so that's why I think the military justice system and the judgment of commanders and as to whether a case ought to go to trial is so important. But I find that a lot of times the warfighter thinks that these prosecutions happen often. They don't. They are very rare, and we're criticized by those outside of the process that we don't prosecute more people. But we're basically not going to prosecute somebody based on hindsight. It's easy to come down after the hill, come down from the hills after the fact and shoot the wounded. But the law is you have to make the decision based on the information and the reasonableness of the actions at the time. So in other words, I think that it is appropriate to do investigations for operational reasons. We have to be aware that the adversary is going to be exploiting these incidents, but it doesn't mean at all that somebody necessarily ought to be punished. It may be that we have to explain what the enemy did to orchestrate this event, or we have to just say we made a mistake, we're going to try to make it right to the best we can, and we're going to try not to have it again in the future. Nobody said that warfare was going to be clean, is going to be done perfectly. It is, Clausewitzian friction applies, and no matter what level of technology that we have. So I do think you can reconcile those, have a very aggressive investigation and where appropriate prosecution, But at the same time, I don't want to see the warfighter start to internalize hesitation, inappropriate hesitation, to the point where he or she puts him or herself at risk and the mission at risk. We have to understand that people have to make very hard decisions with imperfect data under extreme stress. That is the circumstances of combat. And that's why I want the military justice system to be resolving these, as opposed to outside parties or some UN investigation by people who haven't heard a shot fired in anger. So I guess that would be my view of that. Did I answer your question?
Yes, sir. Thank you very much.
Right here.
Yes, sir. Lieutenant Commander Chris Dixon, U.S. Navy. Thank you for your presentation. I have a question. How does this apply when it comes to, say, prisoners in cases like terrorism, where they're American citizens, like we have at Guantanamo Bay, stuff like that, you know, incarcerating people like that? How does what you just discussed there apply?
Well, yeah, if an American citizen chooses to take up arms against his country and become part of the enemy, then that person is and will be attacked just like any other, because as you are well aware, we can't be asking for passports from 10,000 feet. And even if we know in advance someone is an American citizen, in terms of if they're against us on the battlefield, then they're going to be subject to the use of force in the same way as any other adversary would be who is properly designated an enemy combatant under the rules of engagement. Does it mean that there's some additional charges? Yeah, maybe we would charge them with treason in a way that other combatants would not be charged with who are not U.S. citizens. But no, I don't see, and I very recently read the second district court for DC District Court, DC Court of Appeals, excuse me, decision in the Al-Awlaki case, where they made that very point, citing a number of Supreme Court precedents that the fact that someone is a U.S. citizen doesn't necessarily change how they're dealt with on the battlefield. Now, it does change how they're dealt with if they're apprehended in the United States and so forth, and there's other legal approaches. But in terms of when they're on the battlefield and they're shooting at our troops or orchestrating or part of the enemy command and control, then they're going to be subject to attack like anybody else. Okay, the point I was making is we have critics around the world that somehow don't like the idea that we're using technology that will enable us to outdistance the enemy's weapons. In other words, we can attack the enemy before he can bring his weapons to bear. In other words, what I call engagement superiority. And this is really nothing new in the history of warfare. David versus Goliath. Alexander the Great he developed 16-foot spears when everybody else was using 12-foot spears for his phalanx. The Battle of 73 Easting in the first Gulf War, where the Iraqi T-72 tanks, I think they had a range of like 1,500 meters, and our main gun on the M1A1, I think it was like 2,100 meters, so they could be attacked before they could. So the idea that we're using a system that brings to bear our capabilities in a way that the enemy can't is nothing new in warfare. Yet there are people who somehow think that war should be a fair fight and that we ought to be giving the enemy a chance to kill us to make it fair. I don't buy into that. It's not the law. It's not the ethics. I'm very much of a patent approach that the idea of war is to get the other guy to die for his country or die for his ideology.
Next question.
Still there, Martin?
Yes, Charlie. We're waiting for
Okay.
any more questions.
Okay. Jimmy.
Okay, I'll bite. Hi, Charlie. It's Jim Ellsworth. You mentioned
Jim.
the use of law prosecution for treason when dealing with U.S. citizens who enlist on the side of the adversary. That kind of raises an issue that came up yesterday as well, which is, do you see a need for changes in domestic or international law to cope with the fact that declaration of war essentially is now illegal under international law, and therefore we don't have the ability to invoke some of the clauses that would have ordinarily put tools like that on the table?
I don't think that, I have two observations there. One, people bring up changing international law, a lot of different contexts. That's one of them. They say, oh, we need a new treaty for cyber war and so forth. I don't want to sound too cynical. Number one, I think the existing law is flexible enough to address the situations that we're in. Number two, I don't see anything good coming out of an international agreement. You know, this sounds almost arrogant, but the United States has capabilities, and the United States has responsibilities as the premier representative of military, the most powerful military in the world, and the most powerful democracy in the world, that I think that other nations would have other agendas if we got into an international, trying to change international law. I do like the idea of having international agreements on a law enforcement basis, not a law of armed conflict, more cooperation in law enforcement to address a lot of these issues. Now, in terms of domestic law, I see two things that we need to address. Number one, I do think we need a domestic law architecture for preventive detentions. We're going to have people that, we're going to have to detain for a long period of time, not just the people currently at Guantanamo, but we may pick up other people in the future. And I think we ought to have a better legal structure for that. The other thing is, we got to remember that in terms of congressional authorization, we're working off of that authorization for the use of military force from September 14, 2001. And when you go back and read the text of that thing, what it talks about is, people related to the attacks of September 11th. Well, we're 10 years down the road now, and that's getting more and more attenuated, and new groups are coming up that are hostile, that are basically kind of doing the same thing, but whether we can prove that linkage between them and September 11th, I think is getting more and more attenuated. So it may be right to have a national discussion. One of the things that I am concerned about, frankly, is that in the aftermath of 9/11, we have done all kinds of things to curtail the rights of Americans because we don't want another 9/11 to happen. We've permitted the use of national security letters, a lot of access to phone calls, emails, and airport searches and so forth. And I think it may be a time to sit back and say, wait a second, we're a country that has always accepted risk to have freedom and civil liberties. At what point do we want to draw the line and start accepting some risk so that we don't have our privacy invaded anymore? Now, people say, oh, I don't have anything to hide, so, I don't care I don't care if the government reads my emails or whatever. I would say to you that in the intellectual development of creativity, and the entrepreneurial spirit, people have to have the opportunity to privately express unformed or ideas that aren't fully formed without having them observed and taken out of context by others. So besides the abstract notion that we want privacy as a matter of civil liberty. I think it affects our ability to maintain the creativity and entrepreneurial spirit which underlies the free enterprise system, which is the source of our military power. So I do think that we need to sit back and take a hard look at what we've given up. And what I find is kind of ironic is that in the years since 9/11, about 100,000 Americans have been killed by non-state actors. And I'm not talking about terrorists. I'm talking about common criminals. That's how many murders we've had since 9/11. And nobody is talking about having warrantless searches and all this, and flying predators and all this other kinds of things to catch those kinds of criminals, even though as a matter of fact, they present more of a threat. In addition, since 9/11, we've had about 400,000 people killed in traffic accidents, most of which is the result of some illegal conduct. But nobody is talking about deconstructing the whole criminal law system or reevaluating to address that kind of risk. So perhaps it's time that we put the risk in context. And of course, the risk of weapons of mass destruction is a very great concern, and decide where should we draw the line as a society, and where do we really want to sacrifice everything in the name of security, or do we want to accept some risk and have that trade-off? I'm not sure I answered your question, Jim.
Charlie, this is Martin. I think this is probably the last question. You touched briefly on the International Criminal Court and the sort of surprising degree to which it has already reached out. Obviously, the U.S. is not signatory to the Rome Treaty, but can you foresee in the near future an American military person or civilian leader being indicted at The Hague?
You know, my answer to that is no, I can't foresee that in the near future, but I'll tell you, in today's world, you just don't know. I would be very, very surprised. But having said that, I am not so sure that we ought to become a member of the Rome Treaty, which would make us subject to the International Criminal Court. I do accept what the advocates say, that it's very unlikely that a U.S. person would ever be subject to it. But and I'm not so concerned about the politicization. My view is twofold. One, we do a pretty good job at punishing people ourselves, within our system. The second thing is, in the era of an all-volunteer force, do we want to tell those Americans who choose to serve, you know what, we're going to send you in harm's way, and if you do something wrong, we're going to turn you over to a foreign court that doesn't use juries, that lets in all kinds of hearsay evidence, that doesn't adhere to the minimum standards that would be required by a court-martial, albeit they do. So
I agree, we're not likely to extradite anybody. But
yeah.
Because of universal jurisdiction, that might in practical terms mean that identified people can't travel to Europe, for example.
That's already happening. And that is going to be a problem in the future because, I think it won't so much be a problem for U.S. military people who are in a official capacity. But one of these days, somebody is going to travel to Europe in leave status and find themselves, that there's an Interpol warrant out for them or something like that. That is going to be a problem in the future.
How about civilian leaders, secretaries of defense, presidents?
Well, we have some precedent in the international arena that seems to challenge the sovereignty, the otherwise immunity that sovereigns have. I think it's bad precedent, and others do too, but I think that there will be circumstances where senior leaders will not travel to certain countries for that reason. I don't think that's good for the world.
I think we're out of time.
We are.
Thank you, Charlie.
Please
Thank you
join
very
me
much.
in
I really
thanking General
appreciate it.
Dunlap.